and go from there. Well, welcome everybody to today's CSPEN webinar. We're about 8 minutes before the top of the hour. We welcome the over 300 of you who have registered for today's CSPEN HEERF update, Institutional Grant Insights and Innovations. We will be starting promptly at the top of the hour and have several dignitaries that will be joining us once again to assist in this presentation. I'll remind you some of the do's and don'ts as we get to the top of the hour. So please just bear with us for another 8 minutes or so and we'll get started. Welcome everybody.
Hello, can you hear me? Hello, anybody?
Aaron.
Yay.
Welcome, Aaron.
Hey, Aaron.
We've started the broadcast so everybody can hear you, but welcome, my friend. You've got Andrew and Andy and myself. We'll be starting the presentation in another 5 minutes, as we always do, Mr. Board Member. And I'll go through the do's and don'ts, and then we'll get started.
Sounds great. Looking forward to it.
Once again, welcome everybody. We're about 5 minutes to the start of today's CSPEN webinar on the HEERF update of institutional grants, insights, and innovations. As alluded to earlier, we have several key individuals that will be helping us with today's presentation that we'll talk about and introduce momentarily. I'll get to the do's and don'ts in another 5 minutes. We have over 300 registrants and participants on today's call, so welcome as many of you are filing in. We'll get started in about another 5 minutes. Well, good afternoon, everybody, or good morning if you're out on the West Coast, and I hope you're safe on the West Coast and across the country. I want to welcome you to today's CSPEN webinar, the HEERF update on institutional grants, insights, and innovations. We'll be sharing a lot of information with you today, some of it a refresher on recent guidance and recent issues that have been brought forward by the Department of Education, as well as some potential new information that we've gleaned, and a presentation on some things that we at CSPEN wanted to bring to you in terms of innovations that our community has put forward to help safeguard you in your risk as it relates to the HEERF funding. But before we get to that, a couple of the normal housekeeping announcements. This presentation is being recorded along with the PowerPoint presentation. So the audio and video will be available for you for your continued review on CSPEN's website. Give us about 24 hours to post it to the website, but you'll have access to that information after that point. As always, we also offer the opportunity for questions and answers and look forward to the opportunity to try and answer the questions if we can, or if not, turn around and seek the opportunity to go back to our friends and colleagues in the Department of Education and see if we can get those answers. To do so, I'll remind you that on your dashboard, there is the Q&A function. So please utilize that for questions and we'll go from there. So without further ado, we want to again welcome you to today's webinar. We're pleased to introduce the fact that we have three panelists that will be joining me today on this presentation. We have Aaron Lacey, a partner with Thompson Coburn, Andrew Davenport, a senior vice president with Cobbs Allen, and Andrew Mutter, a senior vice president also with Cobbs Allen. So I guess you could say that we start off the day with a AAA rating in terms of the individuals that will be helping me present on the information that we have today. Our agenda will include an update on the latest guidance from the Department of Education, coming attractions in terms of insights of things that we believe will soon be provided by the Department of Education in terms of additional guidance. And as I mentioned just moments ago, an in-depth dive into institutional grant fund risk exposure and some new and innovative ways that Cobbs Allen has potentially given all of our community, or at least those that choose to look into it and within our community, the opportunity to protect against some of the risk of exposure that goes along with that. So without further ado, looking at the Higher Education Emergency Relief Fund guidance and the latest guidance that's been made available. Most recently, the department on September 10th, 7 days ago, notified all of the community that there has been new waiver authority granted with regard to individuals with disabilities under the proposals and under the guidance as it relates to the CARES Act. The information, and as you can see on each of these slides, at the bottom of each slide, we include the actual URL where you can go and get the full documentation and the full information as it relates to each of these issues. But in particular, in just very brief summation, this particular new announcement, as it states, gave waiver authority for a number of the IDEA requirements as it relates to the utilization of CARES funds. Moving on. Literally the day before that, there was new information posted by the department extending the period of time for institutions to apply for the receipt of their HEERF funding. We know in conversations that we at CSPEN have had with the Department of Education that over 98% of the student funding has been dispersed and allocated, and approximately 95% of the institutional funds have been expended as well. What had happened was, however, especially on the institutional grant side, there were some institutions that either were in process but hadn't completed the process by the prior deadline of August 1st. And there were other institutions that the department was surprised to find out had gotten there or had applied for under the recipient certification and application process for their student funds, but hadn't brought forward their application for the institutional funds. In an attempt to provide a remedy for those institutions to have access to those funds, the department made the decision to extend all of the different application processes, those that were eligible for under Section 18004A1, as well as the other sections of the CARES Act that were provided for institutions under Title 3, 5, and 7 for the opportunity for extensions of their eligibility as well. The new deadline for that submission of the application and the completion of that process, as you can see from this slide, is now September 30th of this year. If you happen to be an institution who is either in process or did not move forward with the process of obtaining your institutional grants and would like additional information, again, there's data at the bottom of the screen that shows you where you can go and get the most recent guidance on this issue from the department. And if you're having specific issues, please don't hesitate to reach out to CSPEN or to your various attorneys and other experts for assistance in trying to help complete the process by the new deadline. A number of the institutions that were unable to do so were because of issues related to things like their DUNS number not necessarily being aligned with information that the department had through the G5 system. Other issues that we've seen or heard that have been problematic in the past are just simply that it takes time for the department to process some of these institutional applications, although they're much swifter now because most of the funds have been dispersed, allocated and dispersed. But if you're having issues, please let us know and we'll try and help you out. Moving in reverse order, once again, another key change that was brought forward was, and maybe not as noticed because it was part of the FAQs, the frequently asked questions provided by the Department of Education. They made a minor but important addition to the FAQ that has been out for quite some time on September 8th and included specific new guidance as it relates to scholarships and the utilization of the student portion of the funds, not the institutional, the student portion, for the purposes of potential scholarship funds. The department, modified their original position to state more guidance on the fact that you cannot use, as you see here, the student funds for the purposes of providing any scholarship assistance under the CARES Act for your students. However, the department does say that in limited circumstances, you can use your institutional portion of the funds in order to be able to provide potentially scholarship funds for your students as if you so choose. You'll recall that in the development of the CARES Act and in the breakdown of the funding and the financing, all of the funds that each institution was eligible to receive was broken down into a mandatory utilization of no less than 50% of the funds for students and the other 50% for institutions. Within the institutional portion, you can use portions of that funds for students as well, but at a minimum 50% must go to the students. So on the institutional side and with relation to scholarships, the department did say that you're allowed to do so and provided additional guidance, as you can see here, talking about how as long as those issues and potential scholarships are related to the cost associated with the changes in the delivery of instruction of COVID, that they can be allowed. And the department went further to make sure that they stated that with regard to those scholarships, they must be geared towards the types of educational costs that are related to the disruption and the new forms of delivery for the education. They give you an example here, as you can see, that talks about the fact that one such way that they might consider scholarships to be eligible is to cover the cost for fees to access an online library in lieu of a physical library. Obviously, with the transition to temporary distance education, there's a number of new set of challenges for the students as well as the institutions that you all have been living through since February, March, and beyond. And this is just one way the department is continuing to try to be adaptive and responsive to some of the concerns and issues that have been brought forward. In conclusion, the department also says that the institutional portion is not to be allowed to be used for more than 50% of the institution's total allocation that must be spent on emergency funding. This is, again, a reminder that the 50% of funds for students is separate and apart from the institutional funds, and it's only from the institutional side that such funding and assistance can be provided. And last but certainly not least, two more things. One is another change to information provided by the department in terms of contracted services not performed due to COVID-19. Back on the 1st of September, they provided an updated piece of information on this particular issue and showed that when it comes to the covering of the cost for approved contract services that are not performed by contractors because of COVID, could you use COVID funds for those types of services? The good news is that the department's determination is that the answer to that question is yes. and that in fact you can utilize the funds as long as you can once again show a tie to the issues related to COVID, even if it wasn't directly responsible for those type of circumstances. And at the end of August, one of the key issues that we had been looking for guidance on from the department that came forward on the student side and on the policy side was further extension of all of the policy provisions that have been put forward by the department as a result of the CARES Act, and specific issues that we had been working on, we, CSPEN and others in the community, had been working towards in terms of issues of concern to our students and our schools. As you can see, what they stated was that back in the end of August was that in fact, all of their prior guidance, including in the 5 electronic announcements that began back on March 5th, was now extended through the end of a payment period that includes December 31st of 2020 this year, or the end of a payment, or by the end of the year, or the payment period that includes that date that ends at the end of the federally declared emergency related to COVID. That provides for the opportunity and the recognition that this could extend beyond that December 31st date if we continue to see unfortunate circumstances with regard to COVID going into next year. The good news in the release of this information was the fact that there were some exceptions to those general deadlines, and those exceptions provided some new good information for our community. One of the areas that CSPEN had spent a lot of time talking with both individuals at the Department of Education and up on Capitol Hill dealt with the concerns related to the leave of absence policies. And as you well know, the 180-day limitation in any 12-month period on the ability for institutions to maintain students on the active enrollment status as opposed to forcing to have to withdraw. Under the pandemic and under the circumstances related to COVID, by no fault of the student, the institutions, or the experiential learning provider, and that it was helping provide the tactic or the other additional education for the completion of a student's program and their ability to enter the workforce, there were problems with the ability to do so. This certainly raised its ugly head in terms of individuals in the medical professions, but it struck a chord with not only just medical assistant students and others that couldn't go to the clinics or couldn't go to the hospitals or to the individual practitioner's office, but it also struck all sorts of other forms of experiential learning where maybe simply the employer, whether it be for true trade professions or elsewhere, was no longer open due to having to shut down for COVID, and therefore the individuals couldn't complete their internships, externships, apprenticeships, and others with those type of experiential learning facilities as well. The problem there was that that particular set of circumstances was statutory, and we really weren't sure or didn't think that the department was capable of putting forth new regulations that could address that issue without legislative action first. Well, the department took a long, hard look at this particular issue and made the leap of faith, quite honestly, to state that despite the fact that there is strong statutory guidelines, there's no harm to anybody by providing what they intended and what they did in this particular new flexibility and in this new guidance by stating that as long as that 180-day period was granted after the start of the pandemic and is as a result of the pandemic, therefore tying it to the pandemic, that the 180 days can be extended through to the end of this year, December 31st, 2020. So that grants the opportunity and gives more additional latitude and leeway for all institutions with all sorts of students in experiential learning to have protections and not have to have individuals simply withdrawn due to circumstances beyond anybody's control. They also made modifications that were favorable to the return of Title IV funds policy, not only extending those as well to the longer period of time, but giving additional guidance that was supportive. They reaffirmed the fact that the reporting and audit requirements that had been given a 6-month extension beyond their normal reporting periods, regardless, depending on when your end of your fiscal year is, calendar year, fiscal year, or other, that you had the additional 6 months in order to complete the development and the reporting of your audits and requirements. They also reaffirmed that that the academic calendar had modifications with regard to the interpretations of the number of credit hours in an academic award year, and also provided additional information on campus-based matching requirements and foreign institutions, things not necessarily as directly important to our community, but nevertheless important to the overall community. Having talked about all these issues, I wanted to turn it over to Aaron Lacey and Andy and Andrew, my AAA group, and see if there was anything in this section of kind of a brief review of the latest guidance that I might have missed, or any things that they would like to add to their views and their understanding, or their things that they're hearing with regard to this latest guidance. Any of you gentlemen care to add, or what did I miss?
Well, this is Aaron, and I'll jump in. And first of all, Tom, thanks to you and the CSPEN for having me. Always delighted to work with you all and have the opportunity to participate in these webinars. I don't have a lot to add because I think CSPEN and you in particular continue to address these issues and be so thorough in your review of these issues, which is great. And I'm sure the people on the line today deeply appreciate that. I will just add a couple of 3 points following up on a lot of what you reviewed. I mean, the first is, you talked about this notion based on the new guidance that institutions potentially could use or can use a portion of the institutional share of their HEERF funds to make additional scholarships. I think that's all right, and certainly appreciate you highlighting that new guidance, which was, as you noted, sort of an update to existing guidance. I'll just reinforce what you alluded to, which is the department's position, which I think is the right position, that even if you decide to use these funds as scholarship funds, just keep in mind that they are still part of your institutional share. So when you think about, what you're going to have to document, when you talk about the reporting obligations around the HEERF funds and where you have to report, how you've used student emergency funds versus how you've used the institutional share, et cetera, just make sure that if you decide to use a portion of your institutional share as scholarship funds, that you are nonetheless tracking them and accounting for them and reporting about them in the context of the institutional share, because they are not additional student emergency funds. And it could be easy to miss that distinction because they all, practically speaking, it's all money that you're giving to your students. But just keep in mind, if you go down that road, these are not additional student emergency grants. They are, in fact, scholarships that you are making out of your institutional share and need to be reported and accounted for as part of your institutional share planning. 2 other points, you talked about, Tom, the extension of the deadlines around a lot of the COVID-19 and HEERF guidance, which is great. And I know we were all very grateful from the department. I also deeply appreciate that institutions right now have so much on your plate and you're trying to keep the doors open and figure out how to get people in and get them educated and carry out clinical opportunities and all those kinds of things. And some of this compliance, and particularly the sort of compliance that's out on the horizon, you just don't have time for. I get that. But here's the point I want to make. Right now, many of you are putting into place, you're amending your operations, you're changing things due to the pandemic, and you're putting into place systems and ideas that are built around the temporary guidance. And even though it has been extended through the end of the year, and potentially, depending on how your award year falls and the duration of the national emergency, could extend well into 2021, who knows? But there will come a point where the temporary guidance ceases to be in effect. And one of the things that I want you to have in the back of your mind is, when that happens, when that point arrives, do we know how we're going to unwind those systems and the practices and the operations we put into place that are very specific to these temporary relief provisions and will need to be unwound and rebuilt so that they can comply with standard provisions? Just have that in the back of your mind as you're putting this sort of temporary infrastructure in place, because when things do come to an end, you don't want to be so far down the road that you have a real problem backing things out. You don't want to put permanent things into place, for example, that can't be unwound. And you all who are operators know exactly what I mean. If you build systems and operations around certain ideas and then those ideas go away, it can be very hard to revise and unwind them. The last piece of advice I'll give is specific to this extension of the LOA timeline, and I'm going to put on my very sort of lawyerly hat here and just suggest, first of all, this was a major problem for a lot of schools, as Tom highlighted. I know many of you know this firsthand. You had folks who were on LOA and then for whatever reason, maybe due to their clinicals or otherwise, you couldn't get them back in time and you're running up against the 180-day deadline. So this extension was important. It is guidance from the department. It is in writing. And I don't mean to suggest that you cannot rely upon that. But some of you will remember just a few months ago when on the department's HEERF page, up at the top of the page, there was some big fat red lettering that said, yeah, but you know, our guidance is just guidance and maybe you can't rely on it. Here's what I'm telling you. You know, first of all, you got to do what's right by your students and what works for your institution. Second, I do believe it is reasonable to rely on written guidance from the department. But we have an election in November. We could end up with folks in Washington, D.C. who are hostile to the career school sector in just a few months. And my advice is this: if you do not have to rely on the extension of that 180-day deadline, if it is not necessarily the right thing to do, if you have a way that you could comply with the 180-day window without causing a lot of heartache for your institution, my advice would be to pretty seriously consider doing that. Again, it's okay if you're relying on it. It's written guidance from the department. I believe that is reasonable. But just keep in mind, and Tom made this point, that 180 days is in the statute. And all we've got is some guidance from this administration extending that 180 days. And as an attorney type, that makes me a little uncomfortable, particularly if I've got an aggressive regulator in 6 months coming after me. So be reasonable, take advantage of it if you need it, do what's right by your students. But if you don't need to take advantage of that extra time, maybe consider whether it's something you really want to do. And I will leave it at that, Tom.
Well, and again, we didn't plan this, but you can see that I've shifted to a slide that is also information that we have said repeatedly on prior webinars, and will continue to do so on webinars long after this one. A lot of it because it comes directly from department of officials as well, who are mindful of a lot of what Aaron just spoke of, which is the difference between electronic announcements and guidance versus actual regulatory standards. And given the fact that there are so many changes and things that have happened incrementally as we all traverse and go through this unprecedented period with COVID and the national pandemic and the guidance, it is very important for you to always not only document the words that all financial aid individuals live by, but also date the information that you're documenting as well. Because you're going to be able to, or we hope, that certainly as you go forward and as this guidance comes forward from the department, if you can tie your decision making and your changes and modifications back to the guidance and track the timing of when it comes, certainly we hope, and I hope that Aaron and the other attorneys on the call would agree, that that is at least things that you can do to further protect or insulate or isolate yourself from the very concerns, Aaron, that you just alluded to. It's certainly part of the mindset and the consciousness of department officials that I've spoken to, because again, as Aaron alluded to, they had to put forward the language and the guidance that they did, talking about the difference between interpretation and guidance versus regulations. So these are things that they're even encouraging institutions to look at doing in order to not only monitor and track and show the effective monitoring and tracking of the changes as they come, but how you as institutions integrate and implement that. Fair statement, Aaron?
Oh, absolutely. Yeah, great thing to highlight. Couldn't agree more. And to your point, it's not just documenting, it's dating the policies, because so much has been changing, making sure that you can show what you did and when you did it. And I know Chris McCagran made that point, it really called that point out when you all, when CSPEN had the day with the department.
Andrew and Andy, any comments from the two of you on this before we move on?
No, none here. Thank you.
Yeah, none
No
here,
worries.
thank you.
Just checking in. I know your time's coming. Bear with me. So moving on, and again, part of the reason I think and I hope that we all do this is always ask the experts, and don't be afraid to ask individuals, whether that be your counsel or whether it be your financial aid individuals or your third-party servicing organizations. We are all talking about these issues. It's new to everybody. So again, we're all learning as we go through these experiences together. So while sometimes I know people are somewhat anxious to talk about the regulations or ask questions because they're afraid that they might be putting themselves in a position of looking naive or maybe missing something, I would strongly encourage you not to worry about that as much right now and continue to make sure that you rely on the various different resources that you have, because again, we're all walking through this together as it all unfolds. With that, I have some coming attractions for you. As Aaron once again alluded to, we here at CSPEN have had multiple conversations and are having ongoing conversations with the leadership over in the Department of Education on both the policy side, the individuals that were participants, if you were on our day with the Department of Education back at the end of August, on August 20th, who shared the development of those policy decisions like the LOA issue, R2T4, SAP, and the list goes on and on. But we're also in constant contact with individuals like Deputy Assistant Secretary Chris McCarron, who is the individual on the HEERF, which is the Higher Education Program grant side, that is responsible for the development of the directives and the guidance as it relates to the application for and the administration of the actual grant funds, both the school and the institutional side. And in those recent conversations, you've probably seen CSPEN literally for the past 3 to 4 weeks now saying that new guidance and the long-awaited guidance on the institutional grant side is imminent. Well, I can assure you that's coming straight from the individuals that we talk to. But certainly I and we at CSPEN still do feel like a little bit like we are the boy who cried wolf, because we keep telling you it's coming. The department keeps believing it's coming, but yet we still haven't seen it. So hopefully this makes you chuckle a little bit and know that while we continue to get the guidance directly from the proverbial wolf's mouth, we, like they, are beholden to things sometimes even out of their own control, including additional review by General Counsel's office to make absolutely certain that they double and triple check this before they put out various information, issues with slowing of the timelines, and when things are published in the Federal Register, which is why you've seen the department taking to doing a lot of soft launches of information themselves and acknowledging that this will be printed at a later date in the Federal Register so that they can move the guidance forward quickly. And I also hope you would agree that by showing you the activity from the end of August through the early part of just the last 2.5 weeks through September, it shows you that they are getting more of this institutional guidance out. The frustrating part is that some of the key issues that we're most concerned about and most interested in are the ones that we still haven't seen yet. What I can tell you and what I can share with you with approval from Department of Ed officials is kind of a review and a little bit of what we anticipate will be coming out in the guidance that is imminent and may be out literally later today or tomorrow, or sometime they insist before the end of this month, but hopefully either this week or next week. Keeping in mind, they said that before the end of August and said it for the last 2 weeks as well. But just so that we can go through that and remind you of some of the key things, the 3 areas we're going to touch on here are reporting, the issues and issues around reporting requirements. Then we're going to talk a little bit about payroll, and then we're also going to talk about lost revenue. So we'll start out with reporting. We'll remind you of the fact that the department did put out guidance on a number of areas that there was confusion, and candidly, an area where in this particular instance, Aaron Lacey and Thompson Coburn were at the forefront of bringing to the attention of the entire community some concerns around Attachment A and some of the specific requirements that all institutions in completing their recipients' notification agreement contract to apply for the ability to have access to and administer these funds were not as potentially aware of the new requirements that might come along with that as a result. Several weeks ago, that was, or literally months ago now, that was a major concern when we started to look at a little greater detail of what that might mean and how these additional requirements would force not only tracking of timekeeping and reporting of policies, but would have also and still also would appear to require the opportunity for RFPs and further ways in which to try and look to seek the best contract before doing certain steps that you take in the utilization of these funds. Things that ran counter to the guidance that was coming forth by the department, by Secretary DeVos, and by the actual verbiage that was in all of their guidance of trying to push the funds, especially the student funds, out to the students as quickly as possible. So you had a natural tension that seemed to exist between a number of these procurement requirements and reporting requirements and the goals and objectives of getting the HEERF funds into the hands of students to help with the disruptions related to COVID, and then secondarily, the institutional funds and how those are to be utilized as well. And there's a list, and again, we'll go through and I won't highlight all of these in great detail, but one of the things that came forward as a result of this was additional guidance back on July 15th that talked specifically about how institutions were to report their utilization of their funds and how they were going through this process. And it led to things like new questions about what was FFATA and what was the FSR report. I hope many of you are kind of shaking your heads and remember that it's not so long ago that literally 2 months ago, this was the topic du jour and was the focus of all of us of what the heck are we going to do with these sub-award reporting requirements? Does it apply to us? If it does, how do we go about getting this information? What are subcontractors? How is it defined? Who are they? Does it really make sense? Because these all appear to be things that are regular and routine if you, the department, are giving out grant assistance to a designated institution for research or for other issues or a pilot program, but not necessarily as it related to the HEERF funds and the ability to get either the student or the institutional funds out the door. So as a result, they still talked about how these issues were to be brought forward. And we go through all of this information just as a reminder. And Aaron, I'm going to turn to you for a reminder of all of the details and encapsulation before I give them the surprise and the breaking news. So anything I missed in terms of what you've been tracking and what all the community has been looking at for quite some time?
No, I share your frustration, and I know the community's frustration on how the reporting obligations were managed from the get-go. I mean, Tom, I expect you can second this, but certainly in my career, on more than one occasion, I have seen things come out from regulators and after the fact chatted with the regulators and had them say, yeah, we really didn't anticipate the problems that was going to cause. And I think this is one of those situations where when the department, was moving rapidly to put out the funding and certification agreements, it sort of swept in all of these reporting obligations and made references to these regulations, and they're there in the agreements. But 2 CFR 200 in particular, which is the government, the procurement guidelines, is really problematic. To your point, a lot of people missed it. I mean, we out of the gates didn't see it. And then we started looking at it and we thought, well, wait a minute. And we chatted with our colleagues who do a lot of government contracts work. And we said, is it really the expectation that all these institutions are going to be complying with all of these guidelines, which, by the way, clearly were not designed to apply to career schools? And, unfortunately, where we are is it's there, it's in the agreement. And so there needs to be some awareness of it. Taking a step back from everything you were highlighting and what I anticipate you're going to talk about here in a minute. I mean, I think the department is starting to develop a framework and things are starting to shake out here, right? I mean, and Chris McCarron, again, during the department's day with the department, the CSPEN hosted, talked a little bit about there being sort of the 3 buckets, right? There's the reporting you're supposed to be doing already on your website as to what you have accomplished with the student emergency funds. And the Federal Register announcement that came out a few weeks ago detailing precisely what needs to be on the website, and also indicating that instead of updating that every 45 days or so, that's going to become a quarterly reporting requirement. And then Chris acknowledged that they expect to have something similar developing and coming along for the institutional share. And then there will be some sort of annual report concept eventually that will hopefully just take all that information and won't require a lot of additional reporting, but rather just sort of the compiling of the reporting that's already been done. I think the department has essentially, and I believe this is even in writing, but essentially acknowledged that there aren't very many schools, certainly in the career school community, that they expect to have to do anything with regard to FFATA reporting, because most of you are not dealing with subcontractors or subawardees. I think they basically said, we think this would impact a very small percentage of schools. In my mind, when you talk about those procurement obligations, and most of you I'm sure know, but just to be clear, when we talk about procurement, we're talking about buying stuff with the institutional share, right? This wouldn't happen with the student emergency funds. It would just be with the institutional share, because that's the only context where it would really be allowable. So the question is, I think you have to ask yourself, when you look at what you did with your institutional share, did you go out and buy some really big items, right? Small little things that are routine. In theory, they could be covered by those procurement guidelines, but the stakes are lower, and we're all about risk management. That's what lawyer types like me do for a living. And I would say when the stakes are really low, you probably don't need to sweat as much. But if you received $1 million on your institutional share and you spent $900,000 of that on some product or service, you probably want to take a look at these procurement guidelines and see what you need to do to at least try to paper that you complied with them. And what you ought to do is reach out to your attorney or whoever can assist you with this kind of thing and might have some familiarity. And if you receive $10 million in HEERF funds and you're buying things, you definitely should be paying attention to the procurement guidelines, right? So I would think of it in terms of risk, but it's in the funding and certification agreement. And there are, as Tom, you pointed out on these slides, there are real requirements that relate to how you're supposed to go about and document these big ticket items that you purchased with those institutional funds. The last thing I just want to hit on here that we didn't really talk about in the prior slides, but Chris McGarren talked about, and has been something we've worked with a lot of our clients on, and I just want to remind folks, is understanding, Tom, what you did say, document. Boy, again, I just couldn't agree more. And one of the things Chris highlighted was, if you are trying to cover costs with your institutional funds, particularly salary type costs, costs you paid to existing employees or others for services, it's really important that you be able to put your finger on incremental costs and when and where those incremental costs qualified for institutional funds or qualified expenses that you can use institutional funds to cover. And what I mean by that is, if you were already paying someone to come in and do something that was totally unrelated to the pandemic or any disruption on your campus, and then the disruption occurred, and you paid them more, you paid them additional time, they came in on weekends to build out your online platform or something like that, it's going to be important to show or be able to distinguish between what you would have paid them anyway for the stuff that they always do, and the incremental increased costs that you paid, which would be qualified for HEERF coverage, right? Because they were doing something related to the disruption on campus. And I really highlight this because my concern is, again, I'm looking towards next year and a potential an administration that's hostile to this sector in the White House. And I think if you're going to have folks auditing schools and the way they spent these institutional funds and looking hard in some cases at how they may have paid, salaries and things like that, it's going to be really important for you as an institution to be able to show that what you were paying for was actually a qualified cost. And that notion of identifying incremental costs is going to be really important. And again, Chris hit on that several times. We've talked about it at great length with our clients, and I encourage everyone to sort of be mindful of that idea.
And we'll get to that in literally one of the next series of slides and one of the next major talking points. The good news is the breaking news, and Aaron alluded to a lot of this being foreshadowed by the Deputy Undersecretary's presentation with us back on August 20th, and the information that they have been working on. In recent conversations, a lot of what that Aaron just highlighted is in fact what we anticipate to be coming forward. The breaking news that I can share with you is the following, that the vast majority of the frustrating and confusing issues that we've been talking about in the prior slides with regards to this subcontract reporting, the 2 CFR requirements, and the various different guidance with regard to procurement and reporting policies, it is believed, and it is not ever a guarantee until it is, meaning until we see it in writing, and even then, it's questionable for the future, as Aaron already alluded to, but we truly believe that the vast majority of what is part of these normal 2 CFR requirements and the other requirements will be waived for the purposes of the HEERF grants. As Aaron acknowledged, and more importantly, no disrespect to you, Aaron, as the Deputy Secretary had stated in his conversations with us previously, the department, upon further review, realized that the inclusion of a lot of this information in the certification agreement put everything in a position that was inconsistent with the utilization and the disbursement, administration and disbursement of these funds. It was, again, normal and customary when it's a normal and customary set of grant programs that are going to be monitored and tracked over time, but not given the HEERF and the extenuating circumstances of the pandemic, the drive to move these issues forward. Furthermore, as Aaron said, and coming from Chris and the presentation close to a month ago, literally in 3 days, it will have been a month ago from our August presentation, he did state that what they're going to require in terms of reporting, and in lieu of a lot of what we've talked about here, is something very similar and analogous to what they have done on the student side. And as was stated earlier, that would include the very strong likelihood of reporting of the information on the institutional funds and how those are utilized at date-specific points in time on your website and to the department. You'll recall, and again, we didn't include that as updated guidance because we left out everything that happened prior to our August 20th presentation and all-day webinar with the department, which we encourage you to, if you'd like to know more about that, to reach out to me or to Aaron, because that was part of, we gave that as recognition to those who had registered for our annual conference that had to be postponed, but still didn't want to lose literally the full slate of Department of Ed individuals that we had put together for presentations. So we had a full day literally with the department where they shared a lot of this guidance. Long-winded way of saying that it is anticipated that with regard to the institutional reporting side, similar to the student reporting side, that it will be incremental with date-specific timelines given when we see the new guidance. And as Aaron also alluded to, based on Chris's prior conversations, we do anticipate that it'll be on an annual basis after we get through these initial tranches or initial time periods of early reporting and for the first sets of reporting of this data. The dates that are likely to come out are October 10th and January 10th. Those dates might slip now because, again, the department has not published this information, and therefore it might be hard-pressed and an undue burden on institutions to utilize, especially that first October 10th date, given the fact that we haven't seen the full depth and breadth of the guidance and what is to be done or how it's to be done as we go forward. But the good news here is that the department is sympathetic, and upon further review, as Aaron so eloquently discussed, is looking at ways to make the HEERF process more aligned with the HEERF circumstances and not trying to fit the proverbial square peg in a round hole of making this adapt and making this set of funding adapt to all of the normal requirements and guidance of the grant programs as they would commonly stand. We perceive this as good information and hopefully good, favorable outcomes. The devil, however, is always in the details. And until we see those details, we're kind of on hold, but it seems like things are going in the right direction and in the right trajectory. An area that is also similarly important is one that has been talked about at great length, and it's regarding lost revenue. The Department of Education, in their own webinar back in June, talked specifically about the recipient funding under the certification and agreement and whether or not lost revenue could be included for all of the utilization of the HEERF funds. That includes both the funds that we're eligible for, as well as those that are specifically designated for Title 3, 5, and 7 institutions, minority-serving groups of institutions that have separate guidance and separate statutory guidance that specifically says that lost revenue can be included in the utilization of those funds. Well, back in June, Assistant Secretary King, as a part of that webinar then, kind of made it sound like there could be the utilization of the general funds for all institutions to cover lost revenue, similar to the open utilization of the lost revenue requirement for the Title 3, 5, and 7 institutions. That is not the case. What we have been led to understand is, again, in the notion of breaking news, is that the department will specifically address this issue and talk about the very, very limited circumstances in which they would contemplate or think that the ability for lost revenue to be recouped for all institutions would be permissible, but the vast majority of the circumstances that would be approved under the Title 3, 5, and 7 institutional guidance and allowability is not going to be permitted for the utilization of the funds under the general fund. So while we get what I think is potentially good news in terms of a lot of the issues related to reporting, the ability not to have to go into great depth on the subcontractor, and all of the other information regarding reporting requirements on the tracking, monitoring, and public disclosure of the institutional grant funds, the ability for lost revenue to be part of what you can use those institutional funds for are not as likely to be capable of being done. Last but certainly not least, as Aaron gave me a great lead in once again to, is the area with regard to payroll. There's been a great deal of conversation within our community and within all communities of what payroll can or can't be utilized for under the institutional side of the grant assistance. The only guidance in writing from the department thus far is question 8 on the FAQ, which I've included for you here, that talks more specifically about the ability to utilize the funds of the COVID money on the institutional side for employees and workers in areas like dining halls, dorms, and elsewhere. This is certainly not the same and not as clear on indications as it relates to faculty and other individuals within the administration of the school, as opposed to these workers. Again, essential in many cases, but not really as applicable to our community as certainly other forms of our employee and other forms of the way in which our institutions operate are. So there continues to be discussions around how those funds can or cannot be attributed to payroll, as well as previously, as I said, to lost revenue. One thing I will add before turning it over and opening it up to Aaron again or to Andrew and Andy is that these last two issues, the payroll issue and the lost revenue issue, are two that have been highly, highly touted as concerns by ACE, the American Council on Education, as ones that the traditional institutions and community colleges would like to see addressed. They have been pushing to try and make payroll as extensive as possible and to include as much lost revenue as possible in the general fund, as well as in those Title 3, 5, and 7 funds, as I alluded to on the prior slides. The bottom line here is that we do anticipate, and the breaking news once again, is that with regard to payroll, the department is very, very much aware of the fact that these distinctions on faculty and all of the issues and more that Aaron just talked about are preeminent in many, many people's minds, and they're looking for additional guidance. We believe that there will be considerable new guidance on this issue, and that there will be, quite honestly, again, latitude and favorable latitude given on the way in which institutions are able to utilize their institutional funds for the payment of faculty and other administrators' payroll. Again, it is still all tied back, and we need to always remember that all of these discussions are in the context on the institutional side of being able to apply it back to the disruptions related to COVID, and from an institutional perspective, the utilization of these funds to help bring forward the delivery of education to the students based on that disruption. So that's where I think some of the defining lines, again, will be delineated when we see the guidance coming from the department. But I think that they are going to be, again, liberal, more liberal on their interpretations of reporting, more liberal on their interpretations of payroll, and potentially less liberal or less receptive to some of the concerns of trying to include more lost revenue in their guidance as it relates to the funds that we've received and are eligible to then administer under the CARES Act funds. Aaron, anything that I missed or?
No, I think very thorough, and as always, and we'll yield to the Andrews.
There you go. I have a challenge for all of you all, and the first two that can tell me what this calligraphy signal in Chinese means. I will provide you, and we will provide you with a free registration per Jerry to our annual conference. So I will literally do the Jeopardy song in my head for about 5 to 10 seconds. And if any of you can give the correct answer in that period of time, you will win an opportunity for free registration to our annual conference. So, da-na-na-na, da-na-na, da-na-na-na, 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 da-na-na, dun, 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 dun. Anybody know? It's actually the calligraphy Chinese symbol for patience. And that is what we ask you to have right now. Certainly, it's the one that we're trying to move forward with as we await all of this information. So with a little patience, we hope to see the new information coming forward. And again, as always, make sure that once we get this new guidance, you look to not only CSPEN, but all of your resources to continue with the interpretation and the ability to continue to all of us to work towards making sure that we are compliant with these regulations as they go forward for all the protections and all of the potential exposure to risk that we may have. And speaking of risk and also innovation, we will now turn the presentation over to Andy and Andrew, two of my other A-rated individuals, who are going to talk a little bit about a very unique set of new offerings that they at Cobbs Allen have developed, and ones that we at CSPEN wanted to bring to your attention in order for you to contemplate whether or not these may be beneficial to you as well. So with that, guys, I'm going to turn it over to you, Andy. I'll run the slides, but look to you and Andy and Andrew for the next presentation that I'm so happy that we get to share with the community through all of your hard work and your efforts.
Yeah, thanks, Tom. We appreciate it that you would allow us to be a part of this. Always exciting. My name's Andy Davenport. I am the second A of the AAA rating, although probably a lowercase a. Bring us one step closer to junk. But in any case, I'm with Cobbs Allen. We are an insurance broker, and my group, we help higher education, mostly for-profit education folks, manage their risks via placing insurance. So many of you have met my colleagues, Daniel Cussman and Bruce Denson. We're just excited to be here to talk about this. I also have with me Andrew Mutter. Andrew is our Senior Vice President of Contingent Risk and Special Solutions, which is a fancy way of saying Andrew actually just kind of crawls into a dark space and thinks of all the horrible things that can go wrong in the world, and then creates insurance products to solve them. So I want to thank Andrew for being here as well. So first, what we're going to do is we're going to talk about the history of stimulus risk. you know, we've got some things that have happened in the past that we've learned from, and how HEERF might be applied to some of that risk. We'll also talk about the actual risk that is a result of HEERF. We'll also dive in a little bit about the current insurance world and how those policies would respond to existing policies that many of the institutions might have in place would respond. And then lastly, you know, some solutions that we've come up with to help safeguard you guys from some of these risks. So with that being said, I'm going to turn it over to Andrew, who is going to talk to you guys about some of the historical things that have happened with respect to stimulus risk.
Yeah, thank you, Andy. I have never heard anyone describe what I do quite that way, but I have to say, I like it. I might stick with that one from now on. Yeah, to give you some brief background on myself, I'm a recovering lawyer, as they say, and was you know, a complex corporate litigator at King & Spalding for a number of years, focused on everything from litigating, defending False Claims Act cases to trying to get recovery for companies in the wake of the financial crisis, when they were hit with millions of dollars of claims, suing insurance companies to get recovery. So that's kind of a brief background of where I'm coming at this, and we'll kind of unpack some things that you know, others of my colleagues who have similar backgrounds and are focused on these sort of emerging risks have had similar experiences, and informs in part what we think is coming and where we think institutions should be positioning themselves in terms of risk management. So yeah, looking at this first slide, past is prologue. Probably one of the best sort of analogous situations to what we're facing today is the financial crisis. And in the wake of the financial crisis, the government you know, pumped out billions of dollars worth of stimulus very, very quickly. And what we see from that, on the theme that past is prologue, is that the government tends to follow a pay then chase model, especially with these sort of extreme situations. They are pumping out money in order to meet sort of an unclear, not well-defined set of risks and problems, and then with somewhat murky guidelines, with the expectation that in the end, if anything is wrong, and if especially if things become sort of politically problematic, they will chase the money by looking for fraud and so forth. And probably our biggest concern there, and we've seen it as former litigators, that there's just a strong hindsight bias. Until we'll unpack that a little bit further as we're going along here. The problem with this for you know, education institutions like yourselves is that the government has a very big stick, False Claims Act, that entitles the government to 3 times damages. So whatever a portion of the money and that they allege was misspent, you know, or used in a fraudulent way, that is trebled in the end for damages. And there's strong economic incentives for plaintiffs bar and also for prosecutors, as we'll discuss, to go after institutions for these types of claims. At the same time, educational institutions often don't have the coverage that they need, and Andy's going to talk a little bit more about that. And then we can talk about the solution that we have. So we can go to the next slide, Jerry. Taking a look at the HEERF requirements, as you're probably well aware, in the certification agreements themselves, there is a statement that failure to comply with this certification and agreement, its terms and conditions, and all relevant provisions, and any applicable other law may result in liability under the False Claims Act. As I just discussed, that entitles the government to treble damages. And the FCA liability, you hear False Claims Act, you might think, well, I need to have outright fraud in order for it to be triggered. That's actually not the case. If you look at what triggers FCA liability, it's can be deliberate ignorance or reckless disregard of the truth or falsity of the information being presented to the government. So there's a lot more wiggle room than just straight outright fraud. And from our own experience as litigators, some of these cases can be held together with an absolute gossamer thread of evidence. We've personally been involved in litigation where the government's initial position was that the settlement amount was $1 billion. Now, just to give you a sense of how completely off kilter that position was, the claim ended up being settled for $30 million. That's after years of litigation, and that also is still a huge burden in judgment, and not to include the defense costs in that. The government has signaled very clearly that it's going to have stringent oversight for stimulus abuse. There's been a special inspector general appointed. There's a pandemic response accountability committee appointed, and AG Barr has specifically directed that each district, in each federal district, appoint a specific sort of stimulus fraud czar within their pool of attorneys, of assistant attorneys general, to overlook and sniff out potential fraud. The problem with that, from a sort of practitioner experience perspective, is that you get sort of your worst nightmare as a company is that you've done everything you possibly can to document and do all the things that Aaron and Jerry have been speaking about in terms of best practices to hedge and prevent the possibilities of these kinds of claims. But on the other side of the table, in the government, you get somebody that's particularly young, wet behind the ears, and who is out to prove themselves and are looking for big game. And oftentimes they take completely ridiculous positions, and these are people in the end that are on the other side. Add to that the government doesn't even have to be aggressive itself, or governments can be relatively hands-off in a lot of ways, but key TAM whistleblower suits can still be brought against institutions. And that's a situation where a private individual called a relator comes forward and makes a claim as a whistleblower that the institution has misused the funds in some kind of way. And there is huge economic incentive both for the whistleblower and for the plaintiff's bar on those cases. The whistleblower gets money. The plaintiff's bar obviously is potentially entitled to treble damages, which helps give them a healthy paycheck. And we know for a fact is that enterprising plaintiffs lawyers right now are currently advertising actively to get whistleblowers to come forward, whether it's in education or whether it's in healthcare or financial services. They're actively looking for these kinds of opportunities. So we take a next step, Jerry. Next slide. I'll turn this over to talk about policies.
Yeah, thanks a lot, Andrew. So now that we've identified the risks that are out there, we at Cobbs Island kind of we took a deep dive into insurance just to see what sort of coverage there might be out there for the types of claims that we envision there might be. And unfortunately, the way that policies are typically set up for schools, you've got two policies generally that would attempt to respond to this type of litigation that Andrew went through. The first is your educator's legal, which typically you'll see that the definition of professional services is so narrow. The definition of wrongful act is going to be limited to the provision of professional services itself. That's going to leave out government claims and things of that nature. So once you go and look to your directors and officers policy, which is the other place that you would potentially have coverage, again in the for-profit education space, insurers are keen to a lot of the issues in the space, and while they have granted coverage in many instances, they've limited that coverage or gutted it, however you want to put it, to provide some defense and defense only for the refund of government funds, which is where we think this type of claim would potentially fall. So many times there's not coverage for this, and sometimes when there is, it is very limited to the actual defense of these claims. Again, there's generally speaking, depending on who the carrier is, there's disgorgement claims that you have to get around, or ill-gotten gains is how it's usually described in the policy. Again, government claims and investigations are oftentimes excluded in these type policies. And then when you do have partial coverage, you've got allocation issues with legal fees, and it can just it can just be a mess. So just the way that we see these claims playing out, policies as are generally seen out in the marketplace are just not well or not written well to respond to what we see as the potential risks as a result of HEERF. So we sat down in the education group and kind of scratched our head, and Andrew went into his dark corner and came out with an idea of a way to shift that risk to a different insurance policy, which is super unique. Andrew, hats off to him. He's done this not only in the education space, but in the PPP space and lenders legal liability and all these other issues that a lot of the other industries are having as a result of this stimulus. So with that being said, I'll let Andrew kind of talk about the specifics of this policy that we have crafted or helped craft. And then I think that ought to be it. So Andrew, you want to talk about the solution?
Yep, sounds great. Thanks, Andy. Seeing this risk emerge, recognizing that, also I think as Aaron pointed out, we are in an election year, and there's just such potential strong hindsight bias that even the best actors in this space can potentially find themselves under serious scrutiny, whether it's an audit or an actual investigation, et cetera. We went out to create a policy that would, in effect, allow institutions to take some, to ensure, kind of lock in the value of the money that they're using without it being just a complete Trojan horse of potential liability going forward. So we're working with top-rated, reliable carriers that have actually paid claims on these very terms. They paid hundreds of millions of dollars of claims literally during the financial crisis on the kind of broad coverage language that we have in our bespoke policy. And they still want to write with us. They understand the risk, and they are supportive of this initiative because they understand the risks that so many institutions are facing. And it's the very broadest, best-in-class coverage you can imagine. There's kind of two philosophies in policy writing. One is often the case for most of the policy forms that you'll see, where it's a 40 to 180-page policy, which is an attempt to basically describe every single possible scenario in which there may be a claim and to make some kind of decision as to whether or not it's going to be covered or not. The problem with that is when you have that many words and you have that many terms, you've got just as many opportunities for carriers to deny coverage, especially when they get hit all of a sudden with a systemic risk. COVID-19 exclusions in property policies is a good example. There are some policy forms out there that clearly do not exclude business interruption coverage for those kinds of risks. And yet we know for a fact that the main two carriers that issued that paper are still denying those claims. And they potentially have, they have good faith defenses for that. We don't think that was the intention of the policy, but they were hit with a systemic risk. Policy's complicated enough, and they're able to potentially deny the claim. They will do that, right? I know this quite well from my experience as an insurance recovery lawyer. The other way to approach a policy is to say, here is what we want to cover, and be very specific about that, and then say whatever is not expressly excluded is covered. right? And so instead of trying to describe each and every scenario, you just go ahead and say, this is what is going to be covered. And if it's, don't take the do the business of excluding it, then it's going to be covered. We want this policy to pay, and we want there to be no dispute about it. And that's exactly the kind of coverage that we've created. No room to deny in good faith the coverage, and to pay quickly, and more like a financial product than some of the insurance that you may be more used to, where it feels like you've paid for an opportunity to argue that somebody owes you money. It's 5 pages long with 2 exclusions, one of which is the most pro policyholder exclusion of its kind available anywhere in the market. I think there's one more slide behind this, Jerry. Can you go on? Yeah. The terms that it's going to be backdated, so it's going to cover any activity from the beginning of the liability generating activity. And there's an 8 to 10 year tail on the coverage, and that's because the statute of limitations and the statute of repose, specifically for FCA claims, is so long. And that's another problem, right? You may be fine for the next year or so, but especially if we, sort of have social and political winds change over the next couple of years, your liability is still actually trailing, and there could be a lot of sort of second guessing of what you've done 2 to 3 years later. So you're buying a one-time policy that is essentially covering you for this activity for the next 6 to 10 years. So it's a lot of coverage up front all at once. As a consequence, the premium, you might imagine, is going to be a little more expensive, right? So expected an average of 10%, but that when kind of spread out over the years, that's 1.5% to 1% rate of line over the life of the policy. So it's actually pretty low coverage for the quality and the breadth of coverage that it gets. You can lock in the value of the money you've received and avoid being blindsided in the future by an expensive set of claims that really, right at the time potentially when you can kind of least avoid, at least be able to weather a storm, you get hit with something that really can set you aside. And we've seen that. I think people might be familiar with Heritage going bankrupt right after they received about a $36 million judgment against them in district court for FCA liability in terms of how they mishandled Title IV funds. So these kinds of things are real, and this is we think a really good way to mitigate these risks. So that's it for me. Andrew, Andy, do you have any other additional thoughts or comments?
No, it's it's Andrew and his team have really done a great job here in understanding the risk to schools and putting together something that is, the coverage trigger is very narrow. It's obviously related to HEERF liability, but the coverage is deep, very deep. So you've got defense penalties, the return of the funds. It's really a great product that he's put together to help protect schools, for years to come. So, our job is to, Aaron and all the other wonderful attorneys in the space, do a fantastic job of advising schools on risk, and our job is just to, find ways for you guys to lay off that risk via insurance policies, and this is another one that we've come up with. So yeah, it's a great policy in an uncertain time, and we're just excited to have the opportunity to put something like this together.
Well, thank you guys. Again, we appreciate as well the ability and the opportunity for us to share this information with the community, and your efforts, and again, even going into those dark spaces, which unfortunately is part of our responsibility on behalf of the community, but to come out on the other side of it with things like this, again, is a credit to having so many thoughtful individuals within our community. Andrew and Andy, again, from CSPEN, thank you very much for all the work that you're doing in that regard and on other things, as part of our cadre of attorneys and individuals focused on the betterment of our students and our schools. With that, I am going to open it up for questions. I am going to start with a couple of them that came through in order with regards to some of the preceding slides and information, and walk through those all of you care to chime in, Aaron, Andrew, and Andy, please, by all means, do so as we go through some of these, if you so choose. The first question came with regard to the topic of the LOAs. One of the things, Aaron, before I go through a couple of these other questions, there was a question about your concerns or trepidation with potentially implementing the extension provided. Could you go back through that again? One or two people wanted to hear the caveat emptor, the buyer beware side of implementing that extension.
Yeah, I'm happy to, and I'm not trying to blow things up here. I mean, let me be very clear. You know,
I hope not, because I worked damn hard to get that in there.
Yeah,
but
yeah,
okay.
exactly. No, exactly. You know, my point is, if the right, you know, you've got written guidance from the department extending the 180 days, right? Allowing you to keep people in LOA for a more extended period of time. And my view is, look, if that is the right thing for your students, if it's the right thing for your institution, it makes sense, it's going to help people. I think that written guidance can be relied upon and is reasonable to do so. My only caution is it is just guidance, right? And even this administration has acknowledged that there's a distinction between their guidance and statute and law. And we've got a statute passed by Congress that says you only get 180 days. And that has not changed. So my concern is, you know, and I think this is a worst case scenario, but my concern is, and as a lawyer type, I just have to highlight it, that if 6 months, 8 months from now, you have an administration that's looking for chinks in the armor, so to speak, of career schools and how they went about things, you know, does this create an opportunity if the statute only says 180 days and they say, well, you know, we think that guidance wasn't supported by the law? I think that's a remote possibility. Again, I don't think you should let that guide your decision making if you've determined that the right and appropriate thing to do is to rely upon this written guidance. Here is my point. If you're on the fence, if you don't really need to extend beyond the 180 days, if you've got one or two students where, you know, maybe this would be helpful, not clear, you know, if it's sort of a, we're not sure, it's not a big deal for us kind of decision, then I'm just suggesting you might want to think hard about whether you rely upon it. In other words, if you think you can get it done and do right by your students without taking advantage of the 180 days, there could be a reason to do that. That is all I'm saying. So I'm not suggesting that folks change course. I'm not blowing things up. But what I am suggesting is if you can just as easily not take advantage and go beyond the 180 days without it harming your institution or your students, there may be a reason to do that.
Similar question on, thank you for that. Similar question on the topic of LOAs. What about schools or programs that are not bound by the 180-day limit? I'm not sure exactly what they meant by that, other than to say the 180 days is, again, the statutory requirement for purposes of extending leave of absences. The department, in providing 180 days plus the period of time, if it's inclusive of the 180 days, plus the period of time to the end of the year, is their intent and their goal. And one of the reasons why they felt comfortable in doing this is because they don't see the harm in providing this extension because it's student-centric and student-focused. So that's kind of where the department was coming from with regard to the LOAs. Can they extend their LOAs because of COVID? Again, that is the whole point. The flexibility is as it relates to individuals where the LOA is as a result of the disruption of COVID. Back to some of what Aaron was just saying, if you're talking about individuals where there is no connectivity to the disruption of COVID and with regard to the LOA, then it shouldn't be applied. So in theory, and probably in reality, you're going to have some instances where, as you track this, individuals that for reasons other than experiential learning and the like that you place on leave of absences for justifiable reasons, but aren't needing to be extended beyond 180 days as a result of because it doesn't have anything or applicability to the disruptions related to COVID, you would withdraw those students. And again, I think that the ability to show that you're applying your policies effectively in that regard will further insulate or isolate you to the very concerns that Aaron reasonably and understandably brings forward, because there is that exposure as we all look at the interpretations of new administrations or future interpretations in a new environment. Shifting to a CPA related question, do you expect our CPAs to do the compliance audit, or will the government send out an auditor? I think this is in relation to the extension, 6-month extension, you are still responsible as an institution for the development and the submission of your annual audit with your auditor to the department. What has been granted because of the pandemic and because of issues with, especially early on in the outset, but still with spikes, a number of different places across the country, is the ability for the auditors and others to be on site and participate in conducting the audit with the institution and with the entity and all of the back and forth that is required. There are portions of that that obviously can be done virtually, but the extension was given and granted because there is recognition, especially from the onset, the additional time and changes in the way normal courses of business are going on that required additional opportunity and additional flexibility that the department and others granted. Is the payment to a vendor in excess of $25K, for example, computers, considered a subaward requiring FFATA report? I believe the answer to that is no, but Aaron, I consider you much more of the expert on all of these particular issues as well as others. Would you not agree with that statement?
Yeah, and I'm actually going to ask you to read that one more time, Tom. I just want to make sure I heard it correctly.
Sure. Is a payment to a vendor in excess of $25,000, for example, to purchase computers, considered a subaward requiring a FAFTA report? Again, I don't even think it's applicable, but you tell me.
No, I mean, you know, we would need to double check it, but I think the answer is generally no. Being a subawardee is a pretty specific concept.
I agree. And again, just to try and help clarify the answer to that question, the whole subawardee premise is in the event that you were contracting with somebody else to help you administer and deliver the funds. It's not talking about the development of a contract or the purchasing of the regular equipment or the number of the other things that you can use the institutional funds for and the various guidance that comes along with that. Aaron, did I speak correctly there?
Yeah, exactly. It's exactly right. It's about, you said it exactly right. You're contracting with someone to help you carry out the purpose of the grant. It's not about, you know, hiring a vendor to carry out, you know, something related to your campus, modifications or something along those lines.
And I should have done this at the beginning, but I will do it now just for the sake of making sure that it's included in the discussion. Obviously, all of this is just that, a discussion. None of this is guidance that you should rely solely on. You should continue to consult with your attorneys and great attorneys like that are on this call, but also with your other experts as you go through this, because as you can tell, a lot of this is very complicated and convoluted in some instances. And as you continue to make sure you're complying, you know, always seek out your own best counsel. Another question, if we kept track of our number of hours existing employees working on COVID-related tasks, separating out hours not part of normal duties, can we reimburse the college for just those hours? We've been keeping track since March, but haven't taken any reimbursement from the institutional funds, but wants to be sure we could if we can.
Yeah, I mean, this is Aaron. So great question. And this is exactly what I was getting at earlier. I do think there are instances where if you had employees that you were paying for normal duties and then you had them work on things that were specifically related to the disruption on campus due to COVID-19. A perfect example would be, you know, your instructor who typically comes in and teaches your medical assisting course, for example, you ask them to come in over the weekend and help develop an online version so you can transition online, and that's only something you would have asked them to do and paid them to do as a result of COVID-19. It is my view that that is a recoverable a qualified cost, and I think Chris McCarron basically said that on CSPEN's day with the department. But you know, here's the thing, and this goes back to what we were talking about earlier. I think you've got to be able to document that there was this incremental cost that occurred, and that the incremental cost to you, the institution, meaning this additional amount you paid to your employee, was a qualified cost, was incurred as a result of disruptions on campus from COVID-19. And documenting that can be difficult, particularly if you're doing it retroactively. So especially if you're talking about trying to qualify payroll costs, right? Because the argument being there, incremental payroll costs that you paid only because of the disruption caused by COVID-19, you really want to be careful and be able to document that incremental cost. I'm also very hopeful, and Tom, I know you've said this many times, and Chris signaled this as well. I'm very hopeful that we will get additional guidance speaking to this very concept out of the department as part of what he has indicated is forthcoming.
Correct, and again, we're all hoping for it. Andrew and Andy, a question for you guys on your wonderful presentation. What are the premiums based upon? HEERF institutional portion of the funds, or the entire funds received from both student and institutional portions of HEERF?
Great question. So the premium is based on, you can either insure the institutional portion or the student portion or both. And the premium is based upon the limit that you choose to purchase. So for example, if you took $10 million worth of funds and you wanted to insure maybe 5 million of it, that's the risk that you felt like you had, then the premium would be about $500,000 for a six-year policy. Yeah, so it's based upon the limit that you purchase. Right now, a lot of the ones that we're looking at putting together right now, a lot of folks are choosing to insure the total amount of the funds that they get, and that way it will cover. And not everybody's looking at both institution and student. Some of them are breaking it up, but whether it's the institutional side, you're insuring, $5 million worth, or choosing to choose the amount that that they took, in the hopes that not all the, if there were an issue, the government would not seek to recapture all the funds, but maybe half, and then you'd have half for damages and attorney's fees, the most important portion of a claim, attorney's fees. So that is typically what the premium is based off of.
Thank you for that, Andrew. Appreciate it. Another one, going back to the previous questions about the CPAs and the audits, Mike Weary, who with McClintock and Associates, said, Tom, I think that the audit question related to the testing of the HEERF grants, these funds fall under the financial statement audit, since these audits are subjected to the government auditing standards. The HEERF grants are not part of a compliance audit, as these are not Title IV funds. So if that helps with a further clarification of the prior question, I hope that helps. Mike, thank you once again, not only for your participation and support of answers to questions and for CSPEN, but for keeping me straight with some of these questions. Another one of the questions, when do we expect more specific guidance, and would you recommend waiting to draw down the institutional portion until the guidance is forthcoming? Interestingly enough, that is one of the reasons why the department believes that some institutions didn't draw down and they extended the application process through the end of September. The institutional portion was because they were waiting on the guidance that we are still waiting on even at this juncture. So the short answer is, you can utilize the funds for a number of things that I think that we're all confident are certainly institutional costs directly related to the disruption of COVID and the delivery of the academic programs of your institution. And a lot of those have been included in the FAQs that we've included for you. And if you need additional information, you literally just go to the IFAP webpage, which many of you utilize, or the department's website, and type in COVID, and it'll take you right to the launching pages. And then there's additional sections, or if you need to, once again, just reach out to CSPEN and we'll help. The long and the short of it is, again, we do anticipate that a great deal will be revealed with this new information that is imminent from the department. And when you utilize these funds is kind of up to you. I will tell you that a lot of institutions, again, have already utilized some of their funds, but are holding on to some of their funds either to provide additional assistance to the students, because keep in mind that is permissible. If you don't expend all of your funds for institutional related issues, you can use it for the students, and many institutions have even made the determination that they're going to use all of their funds, both the 50% allocated for students and the 50% even allocated for institutions, all for students. So we have institutions within our community utilizing all sorts of different strategies with regard to this. But again, I do think that there is some prudency to at least seeing what the final guidance shows before potentially expending all of your funds. Aaron and Andrew and Andy, I think that's a pretty fair analysis. Did I misspeak?
No, I don't think so at all. I'll just add a couple other things for people to think about. I mean, one is, if you've got qualified costs that you think would help your institution, your students, faculty, and staff, I'd hate for you to miss the opportunity. I mean, I'm not going to tell you what to do, but the deadline's September 30. So the first thing is, sometimes I find, and you might be surprised to hear this from a regulatory guy, but sometimes I find that concern over regulations results in the tail wagging the dog. And I really think the starting point here should be, do we have a purpose for these funds that's going to help us in our school? I mean, there are obviously costs and regulatory considerations and others, but if at the end of the day the answer to that is yes, then I would be careful about missing the deadline. Though I agree with Tom, certainly my preference would be, if I were in your shoes, to have that guidance before we pulled it down, particularly if the one thing I want to use it for is payroll, for example, or lost revenues. Couple other things to keep in mind under those pesky procurement guidelines, but also just sort of general grant philosophical concepts. There's a notion that when you pull money down, you won't sit on it too long. So, I mean, we really do think this guidance is imminent, like around the corner. But, if you do pull it down, just keep in mind you don't want to let it sit there for weeks and weeks and months, right? So if you don't have a purpose for it and you're sort of waiting for the guidance, maybe you don't pull it down because you don't want it to just sit with no purpose for an extended period of time. I'll also, if you're someone who hasn't pulled this stuff down yet, just keep in mind, and again, I don't want the tail to wag the dog, but when you pull down the institutional funds, there is a burden when it comes to sort of accounting for how they were used that I think is more challenging than the student emergency funds, because the institutional funds can be used for a much wider range of purposes. And so if you're going to pull them down, if you decide that you want to, be prepared to document and do a really good job. We're talking about incremental costs and things like that can be a little trickier than just saying, yeah, we gave them to these students, like with the student emergency funds, and that you'll have to be prepared to do that. But again, for me, the starting point really should be, can you use the money and to make your school a better place? And if the answer is yes, just keep in mind the deadline's coming up.
We'll end on this one, and it's a rather complicated one, and I'll admit that before I even read it. But we'll try and get through at least a portion of this, and then also encourage you once again, because of how complicated or how in-depth this question is, I would encourage you to seek out your legal counsel and others. But can a school use HEERF institutional portions of their funds for lost income, i.e. essentially lost revenue? Our school enrolls new students on a monthly basis. We were not able to start new students for 4 months while ordered to cease in-person and switch to temporary distance education online only. Our income was dramatically reduced compared to the previous year, and would like to use the institutional portion to make up for the loss during the 4 months. Is this acceptable? What documentation is suggested for this situation? Thank you. I'll give you the short version, which is await the further guidance, but unfortunately, I don't think that this is going to be necessarily one where you're going to be able to utilize the institutional funds to cover those all of those costs or portions of those costs. Where I will make a caveat is the department is and has stated that the institutional funds can be used to sustain the operations of an institution during the pandemic, if the, like rent and other requirements. So again, the devil is in the details, and I would again show that calligraphy Chinese sign of patience to get further information before you determine what you can and can't do with regard to a question this in depth. Aaron, am I okay with that answer?
Oh, I agree with you 100%. I mean, I think you're right. The short answer is it's not clear right now. And you should talk with your legal counsel or other guidance, expert providers if you're thinking about this. And boy, I'd sure want to see that guidance from the department if I could before I pulled the trigger.
With that, I want to once again take the opportunity to thank Andy and Andrew, both for their presentation and also for, again, their thoughts and with relation to other issues, as well as thanking board member and also just genuinely all-around good guy. My two Southern boys from Cobbs Allen are fantastic, and Aaron from there in St. Louis is as well, for their participation today. And for your support and willingness to utilize not only your time, but your resources for the betterment of the community, which is the primary mission of CSPEN. I will close with one or two things just very briefly. Please remember that we do have our upcoming conference now slated for October 28th through 30th in St. Louis, back in Thompson Coburn's backyard with Aaron and so many others. We have over 60 school groups registered to be participants in person, and that equates to well over 200 individuals, as well as then vendors on top of that. So we look forward to those of you who would like to attend with us in person. We also are going to be providing the entire conference online in the form of a live broadcast. It will be, many of you have signed up for that live broadcast as well. It will be by certainly registration and invitation only, but will include a plethora of phenomenal sessions that we will be sharing with you yet again in terms of our agenda in the days ahead, probably next Monday when we finalize it. We will still continue to have individuals from the Department of Education. I am proud to announce right now that we have confirmed that our introductory keynote speaker for that Thursday, the 29th, will be Principal Deputy Undersecretary Diane Hour-Jones, and may include individuals above her. And since she is number 2 in command, you can imagine who the other person is, but I won't say her name until we can confirm her as well. But a number of other presentations from Department of Ed officials continuing to work through these issues and clarifications and additional guidance, as well as many, many topics, including what's going on legislatively, what's going on in marketing and advertising, what's going on in innovations with regard to placement and employer and workforce entry on the back end. So we encourage you to take a look at that agenda and hope to see you either live or via the live simulcast in October. With that, I want to again conclude by saying thank you very much to Aaron and to Andrew and to Andy, and not the least of which, thanking all of the over 300 participants that were on today's webinar. We will be posting this webinar and the accompanying slides on our website within the next 24 hours for your additional review if you so choose. If you'd like a copy of the actual slides sent to you, please reach out to myself, Tom, here at CSPEN, and we will get that information out to you as well. Thank you, everybody. Have a great day. Be patient. Know that there is more to come, and certainly then more to discuss. But above all else, be safe, be well, and we'll talk to you again soon. Thank you and have a great day.